I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, my partner asked me to sign a prenuptial or postnuptial agreement. Do I need to hire an attorney?
That's a good question, Emily. And it's a question we get a lot. A lot of individuals don't understand if there is an obligation under Connecticut law to hire an attorney of their own. So to clarify, Connecticut law does not impose a legal requirement for a party to a prenuptial or postnuptial agreement to retain an attorney or to be represented by counsel at the time they enter into the contract. However, the Connecticut law certainly does impose a requirement that the parties have a reasonable opportunity to consult with independent counsel. This does not mean that the parties need to actually consult or that they need to retain an attorney. It just means that they need to be given the opportunity to do so. And if they wish to do so, they can. And if they decline to, that's fine too. The courts define a reasonable opportunity as sufficient time before the marriage. And now this seems a bit vague, but it's because the inquiry and facts vary from case to case, and so it's a very fact-specific inquiry for the court. To the extent that either party does consult or retain an attorney, it's important that the attorney is conflict-free and is independent. So what does this mean? A conflict-free attorney is an attorney who does not have a conflict of interest as between the two spouses or prospective spouses, or as between one of the parties and a third party. What does independent counsel mean? Independent counsel means that the attorney only represents one of the parties and is advising that party only. So often we have a situation where one party is represented by counsel, so let's call them party A and attorney A, and the other side is representing themselves, party B. Party B and attorney A will often have to work together to try to come to terms on an agreement. And so they may exchange drafts of the agreement, they may have discussions about the different provisions or implications of the agreement. Party B may share their concerns with certain provisions of the agreements or their goals. Party B may ask questions of attorney A. What does this mean? What does the law say? And party A, attorney A, no matter how helpful they may be or how nice they may be to party B, it's important for party B to realize that they are not represented by opposing counsel. Opposing counsel, attorney A, is not there to protect their interests, is not there to ensure that they're getting a fair deal, and certainly any information that party B shares with attorney A is not considered privileged or confidential. So sometimes it can be confusing when you're working with an attorney, and you may feel like that attorney is really advocating for you or representing you. If it's not someone that you've signed an engagement letter with and it's not your independent attorney, then that attorney does not have an obligation to keep your discussions confidential, and that attorney does not have an obligation to advocate for you or to protect your interests. Now, in this regard, it's important for the parties to memorialize in the agreement if either party's been represented by counsel, and if so, who those attorneys were. And it's important for the agreement to also clearly specify that any individual or any party to the contract that did not have an attorney was still given the opportunity to consult with an attorney and voluntarily decline to do so. By clarifying these circumstances in the agreement, you can help prevent, hopefully, challenges to the agreement later when one party says, well, no, attorney A did represent me, or attorney A did advise me, or no, I wasn't given a reasonable opportunity to get my own attorney. By specifying in the agreement what the circumstances were, it can help diffuse any kind of confusion or challenges later down the line. So certainly, if you have any questions about this requirement, consult with an attorney, and we can help dispel any confusion as to what the obligations are.